Good afternoon. My name is Samantha Breslow. I am your moderator, your referee throughout this cage fight. But before I introduce your two fighters, I want to explain the format, the ground rules, and kind of walk you through the process. So to the extent that you are seeking credit for this, there will be polling questions throughout. Please answer those. And if you have any technical issues, don't worry. Hillary will be on here moderating. And if there are any issues, reach out to her and we can resolve that after the webinar. So don't worry if there are issues, because often what we see is if you're logging in from your phone or maybe not using the platform on your computer, that sometimes they just don't pop up. So again, don't worry about that. As far as the ground rules go, I have the ability to mute these guys, to use a timer if they're going on and we need to cut them off. And I think most fun for you guys, we will have a lightning round at the end. So to the extent that you want them to debate or to talk through any questions, please send them in the chat to us. And at the end, I will go through them and pick some favorites and we'll do a 1-minute lightning round. And again, I think either through the chat or the Q&A, and we'll organize them there. As far as the topics go, there are going to be a few topics we're going to work through. So the first being jurisdiction to tax, Nexus, then fair apportionment, discrimination, and then again, the lightning round. So if those look familiar to you, it's because it's following complete auto more or less without the fairly related prong. So that's going to be the format, and I'm sure there's going to be some bouncing around, but that's going to be generally the structure we're going to follow for both income tax and sales tax. So there will be questions related to both as we work through it. So I think with that, unless you guys have any other technical issues, I think it's time to introduce our two fighters. So in the virtual corner of the ring, our first fighter started his training in Chi-Town, but is now a Washington, D.C. native. Some may consider him an underdog, but you shouldn't underestimate this fighter, folks. What he lacks in years, he makes up for in his knowledge of constitutional insult theory. Around the office, he's a professor of sorts, but in the ring, his pen is mightier than the sword. Please welcome Christopher the Professor Lutz.
Yo.
Our second fighter hails from an RV in the sandy shores of Lower Alabama. They call him the fisherman, not just because he spends his afternoons by the water, but because he reels in his opponents and spits them out. He may be a salt veteran, but he'll run circles around you in the ring. Jordan, the fisherman Goodman.
AKA the Unabomber.
I was waiting for some sort of commentary. So before we get into the first round, we do have our first polling question, again, for purposes of getting credit. So I'm gonna unleash that now, and here we go. Has your company or clients received a Nexus questionnaire from a state Department of Revenue? Your options are since the Wayfair decision, they've gotten one, so since June of 2018, in the last year, not at all, the states have skipped straight to audit, or it's just not applicable. It's not a concern, you're already filing in most states. So far, looks to be weighted more towards it's not a concern. You're already filing in most states, or in the last year you've gotten one. This was something that we raised because it seems like taxpayers are just, my fighter says don't. All right, I'm gonna end the polling. Here are your results. Wow. So yeah, it's leaning more heavily towards in the last year, and it's not a concern. All right.
Surprising.
Not surprising. With that, let's get into our first round, which is again related to Nexus and jurisdiction to tax. So when Wayfair was decided back in June of 2018, it more or less set the stage for a mass adoption of state economic nexus thresholds for sales tax. At this point, all but 2 states, Florida and Missouri, have adopted an economic nexus threshold. And although these bright line rules were arguably created clarity for certain taxpayers, because you don't have to mull over physical presence any longer, there are still certain ambiguities. So our first question relates to the transactional threshold. And how do you calculate the transactional threshold of a state's economic nexus standard? Is it based on each agreement, is that a transaction? Is an invoice considered a transaction? And let's put this into practice, address it in the context of software. So Jordan, you're a talker. I'm gonna go ahead and put you on the clock for 2 minutes.
Oh
How
my
do you
God,
define a
really?
transaction?
Well, first off then, since you're only giving me 2 minutes, first thing I have to do, I go, it's a false premise. Yes, originally the South Dakota statute had $100,000 and 200 transactions, but that has been falling away. And the reason why it's falling away is that it's stupid. It's stupid, and states are recognizing the fact that it doesn't mean anything. Brought up that the U.S. Supreme Court was that if Pinterest with $11.10 average transaction had 200 transactions, it would generate $2,200 of revenue in the state, and that is far below the $100,000 statute. The reason why we haven't got clarity on it is because it's going to go away. Just for way of example, Alabama, Arizona, California, Colorado, Idaho, Iowa, Mississippi have eliminated the transactional part. New York and Connecticut and Massachusetts, Minnesota have made it an and test. It's an and test. Even the proposals in Florida and in Missouri do not have a transactional test attributable to it because it's just stupid. There's no reason to do it. How do you measure that? How do you, if you have one transaction for $1 million on a software contract, but you get updates every month? Is that one transaction? Is it a number of transactions? Is it how I write the contract? Certainly in the context of let's use this as an example. Here in Alabama, we use Amazon a lot to deliver a lot of essentials. Sometimes I order a bunch, it comes in one box. Is that one purchase? Is that 3 transactions? Is that 15 transactions? There's no way to tell. There is no definitions of it. And the reason why is because the legislatures have found they haven't had to focus on it because that's usually not the issue. We do have some low margin, low sellers who have, dollar transactions. They get to 200 and are concerned about it. I would push back because if the whole purpose of the Wayfair statute is $100,000, that's the de minimis to protect people. The 200 transactions is irrelevant. You're absolutely right to identify the fact that it hasn't been challenged. It hasn't been clarified because nobody cares. That's not your threshold. I would advise people, don't worry about it. Focus on some other things.
All right, so Jordan says nobody cares. Chris, what's your response? How do you calculate it? Do you also think that nobody cares?
How defeatist. I'll tell you, I've represented a client who had a Massachusetts audit, and in any given year, they either satisfied the dollar threshold or the transactional threshold, but in no year did they satisfy both of them. So we got an audit initiation. We went back to them. We said, here are the numbers. 96 transactions this year. We exceed the receipts threshold, but we're under the transactional threshold. Auditor walked away. So I do think there's some value for certain types of sellers, particularly remote sellers. But I think that the software example sort of does support Jordan's point, which is that, if I engage in $1 million transaction with 1,000 different licenses associated with it, is that one transaction? Is it 1,000? Is it every month I invoice them? We don't really know. But if we're being honest, for somebody who's getting millions of dollars on individual licenses, I think we've already crossed the Rubicon there. The answer, I think, unfortunately, for most taxpayers is you already have Nexus everywhere.
All right, so what's that?
And to Chris's point, and while he'll take credit for it, I know he doesn't deserve it. Mass has changed, right? It was stupid to have the or, and they said, okay, now it's an and. You have to have both 200 transactions and $100,000, and that to me is just a transition away from having any kind of transaction base. It will be gone. And keep in mind also, Mass is the one that's been pursuing the cookie Nexus pre-Wayfair until they got their butts kicked at the ATB. We're still waiting for the formal decision, but it was thrown out, right? So Mass has been overstepping for decades, and particularly with use tax collection obligations, certainly since 2017 with their failed regulation experiment, then their statute that kind of went back. They've messed it up all over the place. So I don't use Mass as a good example.
All right, let's move on because it sounds like you guys are both in agreement.
My client does.
Let's move on because I think you guys are both in agreement that for purposes of the transaction threshold, it has flaws, but it really shouldn't be that much of a deciding factor because most taxpayers are probably either over this threshold with receipts or exceed the transaction threshold. So let's focus on a state that still has, I think, quite a bit of ambiguity when it comes to sales tax and the threshold, which is Kansas. So as I mentioned, there are 2 states that don't have a threshold currently, but Kansas did it in sort of a strange way. Back in August of 2019, they broke trend with the other states, and instead of adopting legislation, They published guidance indicating that an e-commerce seller who makes sales in the state has Nexus, but they don't have a small seller exemption, meaning there's no threshold. There's no $100,000 in receipts. There's no transactional threshold. And in response, the Kansas Attorney General, a month later, issued an opinion saying that it's not valid, not following the department's guidance. And although the legislature has adopted, or as proposed rather, a couple of bills, neither have been adopted to impose a transactional or receipts threshold. So question to you, let's start with Chris this time. Is Kansas's economic nexus law, is it effective? Is it enforceable without the small seller exemption? And if it is this a more practical state approach rather than having a bright line threshold that's going to have to be adopted with inflation over time?
I think if the question is it facially unconstitutional? The answer is no. I think it's facially constitutional. This is the kind of thing that states did back in the 80s, the National Bellis Hess statutes. Even Alabama, before they adopted their rules, had the same kind of statute in place that they pointed to and said, if you're doing business in the state, you have Nexus, period. The argument is more as applied to certain taxpayers, is there a constitutional problem? And I think the answer is yes. If we go back and we read Kennedy's decision in Wayfair, he doesn't say that you have to have the thresholds. He says those are some of the things that did save it from a Commerce Clause analysis. But at no point have we been told you must have a threshold. If somebody is doing a sufficient amount of activity in Kansas, and millions of dollars of business, et cetera, they'd have a hard time, I think, arguing that, well, they can't assert Nexus over us because they don't actually have thresholds. That being said, a very small seller with de minimis activity in the state, of course, they could still raise a de minimis exception. And even though the statute doesn't have a de minimis exception, the Constitution does.
Jordan, you disagree? Go for it.
No, I'm just saying he just talked out of both sides of his mouth, which he is wont to do. He started off saying it's not facially unconstitutional, but then he said, but there's always exceptions in the Constitution. So I'm not sure what his point is here. I will tell you, based upon case law that the court has looked at and told us in the Wrigley decision, they definitively said that every statute and the Constitution has de minimis exceptions. They absolutely do. So the fact that
what I just said
alone, Kansas goes at it alone, saying you have a single sale, or you try to sell in our place, you have a website, we'll make it available. Absolutely, the court would step in and saying you can't impose it on everybody. It's not fair, and there's a fairness perspective to it, because at some point you have a single sale, now you got to report, and you got to spend money getting people to do your tax returns, people to collect and remit on your behalf, and all of a sudden there's a cost associated with that. And then the question is, from a Commerce Clause, interference with Commerce Clause, how much can I allow to involve interstate commerce here? If you make the cost of doing business in a state so great at such a low level, there isn't a constitutional protection against that. You may say that it's due process, you may say that, but I would tell you it's Commerce Clause, because that's the impediment. That's the reason why de minimis exceptions does. And the court has been on the record saying that it does have de minimis exceptions to all statutes and all enforcement of the Constitution.
So you're saying if somebody went in with a declaratory judgment action against the statute, facts be damned, that they would prevail on a constitutional challenge to Kansas's law?
I would argue they've got a good shot at it. I mean, of course, it's going to be. So your question is it facially unconstitutional?
I'm not taking that case.
You know what? I'll step out and I'll say
the question was, is it enforceable?
It is
which I think is one of the
unconstitutional to impose a burden on a person that has, and we have to define it, a de minimis amount of sales in a state. Yes, I think it's there is some minimum threshold.
So as applied, there's a constitutional challenge, but as a facially,
No,
unconstitutional.
I mean, South Dakota's was upheld facially because it established a de minimis exception. Okay, that was a facial challenge, not a specific challenge. It wasn't Wayfair was anywhere near the threshold. It's whether $100,000 on the Constitution made sense. And the court said, yeah, close enough for government work. And I would say that 0 is not close enough for government work. 0 is too low. And then if it goes beyond 0, what if you just have a website that's available in the state, but you can't sell a darn thing to the state, but then you have an obligation because you're selling into the state, even though your receipts are 0, you have an obligation to file an annual return. That would be too
Chris, one sentence summary, Jordan, one sentence summary, and let's move on.
Kennedy did not say that the safe harbor was mandatory. He said it was one of the factors that indicated the statute was not unconstitutional.
I agree, because it wasn't before them. The court just wanted to address questions that wasn't before them. The question was, is this standard today the right standard to overturn Quill? And he's, of course, the one who invited it, 2 years earlier. I believe that the U.S. Supreme Court would say facially, you could not impose a burden on interstate commerce if you have no sales in the state or you have $1 worth of sales in the state. I think they would uphold that. Now, Sam, a question that you asked, I think that is not answered here is where is that bright line first? And is $100,000 of South Dakota sales equivalent to $500,000 in California sales? Okay, you got to ask yourself that question. And then number two, anytime you have a bright line, there are always facial challenges because I'm at 99,999 versus 101, and why am I paying tax and they're not? So there always is an issue when you have a bright line.
That was the longest one sentence I've ever heard, Jordan.
I didn't take a breath. I did not take a breath the entire time.
All right, so with that, I'm going to move on to our next question, which is still in the same vein, related to Nexus and localities. So with respect to local indirect taxes, many jurisdictions still don't have Nexus standards. So for example, City of Chicago, where I am, and Jordan sometimes is, the City of Chicago Department of Finance hadn't addressed Nexus prior to a recent ruling or guidance that they put out, indicating that as of January 2021, we have a safe harbor of $100,000. You have a state like Colorado, which is still sort of sorting through how about 35 other 70 local jurisdictions are going to deal with this economic nexus threshold. So Chris, since we just heard Jordan for a while, can you give us a quick explanation of whether these local jurisdictions, what standard applies? Would it be the state's bright line standard, or is there some sort of constitutional threshold you should look at instead?
Well, I think I already showed my hand in my answer about Kansas. I do not think that localities need to have statutory thresholds or standards. I think once you've created a nexus with a state, the Commerce Clause isn't really concerned with interstate activity. So you're in the state, it just becomes a due process question. Bread and butter, first year of law school, did you purposefully avail yourself, of that jurisdiction's services, et cetera? And that becomes the sole analysis. Now, what if, though, you don't have nexus with the state per its statutory thresholds, but a jurisdiction says you do? A place like New York City, for instance, very well might go that route. It comes down to whether there's a constitutional bulwark against them being able to assert jurisdiction. And I really just think that the threshold for that nowadays is really low. And if you're going to go into court on that kind of just pure jurisdictional argument, it's kind of a loser. But I do think that if you can point to the state's threshold and say, we don't have nexus for state purposes, I think you're on pretty solid footing.
Jordan, 1 minute, go.
Disagree. Okay. Due process says no state or political subdivision shall deprive any person of life, liberty, or property without due process of law. The fact that you have the right to impose a tax should also give you the obligation to say when you're subject to the tax. Sucking up to the state statute isn't sufficient. Each of these taxing jurisdictions impose their own types of taxes and their own way to doing it. And I applaud Chicago. They stepped up. I'm not sure what's going to happen retroactively before July 1st, 2021, because it says it's effective that date, but they did the right thing, as have some of the Colorado jurisdictions. They have passed their own Wayfair-esque statutes. Maybe it's not $100,000, maybe it's less, but there's an obligation to let taxpayers, corporate America, know whether you're subject to tax or not.
Does it matter to you that the localities are separately administered or not? Does that matter to your analysis?
It might, because if it's just an add-on tax at the state level, then it's just an add-on tax at the state level. But certainly the extent you have to pay it separately, report it separately, collect it separately, and report it that way and pay it over, absolutely have an obligation to impose the tax.
My answer to this question does not change whether it's a home rule or whether it is not a home rule jurisdiction. Even
Chris,
if
you're just dead wrong, man.
And the reason for that is the Constitution is unconcerned with state structures, within a state. A state legislature could limit a locality's ability to assert nexus. They could, depending on that state's constitution. But Nexus is unconcerned with a state constitution. Nexus is concerned with the United States Constitution, and home rule doesn't matter there.
Okay, so what part of the due process clause that says no state or any political subdivision or Indian tribe? But I
already said that you always have a due process defense. Bread and butter, first year law school stuff. Did you purposely avail yourself of that jurisdiction? But the answer is that is an extremely low threshold.
Well,
let's move on to income tax
process. You can be subject to a product liability suit in that jurisdiction. No constitutional argument there.
I disagree there, because the product liability cases are going the other way. They're actually pushing due process and saying, even though you knew it was going to end up there, that isn't enough. We've gotten rid of those tests. McIntyre, Who else am I forgetting about? All those cases now with product.
McIntyre, Goodyear, those cases don't say that. I mean,
were saying
if
the
you
context weren't
intentionally send
sufficient.
something to a
They knew that-
jurisdiction,
They knew that the goods were going to end up in the state, and that wasn't sufficient.
I'm muting you both. We're moving on to income tax nexus in the context of public law 86272. This is something that I know you guys have both debated with me in different fronts, which is, so public law 86272, it's been viewed by a lot of practitioners as toothless. The latest hit to its authority came with proposed revisions to the MTC model statement, where they've sought to update public law 86272 by adding activities conducted over the internet. So for example, if a business interacts with a customer via its website or app, according to these new revisions, the business activities would exceed 86272. And Cost has suggested that these proposed revisions will eviscerate public law 86272. My question is, wasn't this already done via market-based sourcing? For example, if a remote seller's receipts from services are sourced to a state under market-based sourcing, and its activities don't otherwise exceed solicitation, can the seller claim 86272 protection? I know you guys can go on for this for a while, so I'm going to give you both 1 minute and then maybe a rebuttal. Jordan, 1 minute.
Okay, well, first off, I disagree. What the MTC is doing is death by 1,000 cuts. It's unfair to corporate America. If 86272 has outlived its 6-month usefulness 50 years later, 60 years later, then so be it. Let Congress act on it. So the first thing that the MTC is doing is just wrong, because they're going to pass it. Some state's going to say it doesn't apply. If you have cookies in the state, they're going to sue, and you have historical liability, which isn't fair. Okay. Number two, I disagree that market-based sourcing is the cause of this. It was the adoption and creation of Finnegan. For all the people known that file in unitary states that have adopted Finnegan, you have 86272 protection, and the state says, okay, great, we won't tax you, but you're a member of the unitary group, so we'll include your income in the base, and we'll include your receipts in the numerator. I don't know what the difference is, whether I'm subject to tax or not. So I think it's pre-market-based sourcing. It deals with tangible personal property and the adoption of Finnegan in the throwback concept, or the throw and inclusion concept, that eviscerated it. 86272 is still on the books and must be defended. To cut it by 1,000 slices, it's just wrong.
Chris, 1 minute rebuttal.
Hawaii is wrong. Hawaii has adopted a statute that says if you exceed their factor presence nexus standard, that in and of itself kills 86272 protection. That renders 86272 a nullity, and I look forward to somebody challenging that. What the MTC has done, the proof is they refused to acknowledge what the yellow pages were back in the 50s and 60s. The idea that you could call somebody that was a customer service rep who would give you the exact same kind of support that a website gives you now. Yet the website kills 86272 protection. The yellow pages didn't. That's nonsensical. And Brian Hamer has basically said, we've just chosen not to touch it. I actually looked at the attendee list to see if he was here so he could defend himself, but he is not. Yeah, I agree with Jordan in that respect, that either 86272 means something or it should be abrogated, but it can't mean nothing and not be abrogated.
No, and understand, this is a federal law. It is a federal law. And to the states adopt an economic nexus, that's a state law. And when a state law and a federal battle against each other under the supremacy clause, the federal law should reign supreme. For them to take, again, dicing and slicing this is just preposterous to me. It really is.
My slides are trying to move you ahead. So we're going to go to our second polling question. We're done with Nexus. We're going to move on to apportionment.
86272 doesn't apply to digital goods in my mind, but there is a question about that based on whether the digital goods are characterized as TPP under state sales tax law. I think you have a tenable argument if it's TPP.
Yeah, no, think about it. In the old vernacular, canned software was considered tangible personal property for sales tax purposes. And now does canned software not apply for 86272 purposes, right?
If a state characterizes it as TPP on the sales tax side, can you apply that same analysis on the income tax side?
I sure would.
Of course you can. Of course we will, if it behooves our clients. Their argument is saying it's a different tax code. We could use different definitions. We're not bound by it. But again, part of the reason you publish statutes is to make people aware, right? They have to be aware of what the rules are. And if this is your only pronouncement as to what this category of things are, why not rely upon that?
Yeah, with that, our second polling question is moving on to apportionment again. So has the state's adoption of market-based sourcing created audit or filing issues? Overwhelmingly, it seems like the audience agrees that yes, it has, and we've been engaged in audit by one or more states. I'll show the results to you in case you care. But what's sad about these results is that only 8% has actually reached a deal with the state.
Sounds like 92% might need our help.
Exactly. All right, so we're going to move on from our second polling question and again on to fair apportionment. And the first part of that is market-based sourcing. So states have been moving from cost of performance, COP, to market-based sourcing over the last decade. And many states were already pushing in that direction. You look at a state like Pennsylvania that moved from COP to market in 2014, but they were already sort of enforcing their law as a market-based sourcing regime in audits, and that led to the Sens decision. But although states sought to clarify the law with market-based sourcing, receipts can be sourced in several different ways depending on how market's defined, including where customers are located, where services are performed, where the benefits received, or where the customer's customer is located. And that was recently put to the test in two cases in Ohio and Washington, where the State Department of Revenue sought to look through to the ultimate customer when sourcing receipts of intangibles. I'm going to kind of lay out these two cases so they can debate them. One was a Washington case, Lending Tree. Lending Tree was paid by lender referrals. So it sourced its receipts to the location of its clients, the lenders. And the department took the alternative view that the benefit was received at the prospective borrower's location, so the lender's borrowers. The court ruled for the taxpayer and determined that the service is ultimately received at the lender's business location. And the court's rationale was that the business activity related to the Lending Tree service, again, was the lender's receipts and their evaluation of the lending referrals. So they refused to look through to the lender's borrower. In a similar case out of the Ohio Supreme Court, the taxpayer's defender, they're an authorized ADT dealer that advertised for ADT in Ohio. They did the installation, again, they did the advertising, and then they sold the contracts to ADT, who then performed the remote monitoring services from locations completely outside of Ohio. So defenders outside of Ohio, but their customers are located in the state. What's important is in the statute, it provides that the physical location where the purchaser ultimately receives the benefit is based upon where the proportion of the benefit is in the state. So the department argued that although the gross receipts should be sourced to Ohio, because there wouldn't be any receipts if not for those Ohio customers. You just wouldn't have any receipts if the customers of ADT weren't located in the state. The Ohio Supreme Court ultimately rules for the taxpayer, saying that the receipts are cited to the location where ADT, which is defender's customer, realized the benefit from those intangible contract rights. So COP was a headache. That analysis didn't make it easier on taxpayers. But after I've just talked to these two latest decisions, Chris, 2 minutes, is market-based sourcing really an improvement over the old COP rules?
If Lending Tree and Defender are correct, it is. I'm concerned that Lending Tree and Defender, which are meaningful, substantial taxpayer wins, when we're looking back 10 years from now, they may be the minority of authority with respect to this question. In fact, Washington alone has regs on the books that still would contradict the Lending Tree decision, when it comes to apportionment of legal services, for instance, and where those are received. They say you would have to use your client's apportionment factor in the context of a product liability case. So I do not think it is easier in practice, but if Lending Tree and Defender really allow us to just go with whatever our books and records say our customer is located, the payor is located, well, that would be great. It's just not what's happening in real life. In real life, we are seeing very convoluted, complex determinations of where the customer is located, where a service is received. And, let's go back to Washington State. Jordan, how many times were we up in Olympia arguing this exact same case, and the Department of Revenue was not backing down? I'd be curious to know, are they doing any better now on current audits? My guess is Lending Tree was a little slap on the wrist, but they're going to keep doing what they're doing, and they're going to try to distinguish away Lending Tree. Another thing that just makes me uneasy, and I don't know if it's just a coincidence, is why are these both gross receipts taxes? You know, where is the case in the income tax arena? That's something that, you know, maybe, like I said, maybe it's just a coincidence. But I'll never forget, you know, back in Georgetown conference in 2015 with Michael Fatale talking about how, look, you guys are saying market-based sourcing is difficult. Where are the cases? We're not seeing any cases. And the answer was, well, we're arguing over economic nexus and alternative apportionment. The cases are here now. That's what we're seeing right now is the sourcing. What is a market? And states have, even just statutorily, at least 4 different definitions of what the market is. So it certainly isn't easy.
In response to that, Chris, I'm going to agree with you in large part. How many cases have we argued around the country where the states take different positions on the same taxpayer, and how that possibly could be the right answer is beyond our comprehension, right? We say we'll do it the same way everywhere in every state, and they go, no, our statute says X, you have to do X. You go to the next state, well, our statute says Y, we got to do it that way. This whole thing has been an abject failure, this transition to market-based sourcing. The purpose of it, from a theoretical perspective, was because cost of performance was too hard. You had to get cost accountants in, and no one likes dealing with cost accountants. So we're going to make things a little bit different, and we're going to look to market-based customer, because that's where sales are. We're getting away from property and payroll. We're looking at sales. This was a good move. But then they clouded it up by, you know, where the benefit is received, where the benefit is enjoyed, where you deliver the service, these concepts that nobody knows. And then they compound it by bringing in what really is an archaic theory to source this. Let's look at billing address, okay? And I look at Lending Tree, and I look at Discover or Defender. It's a really simple question. If we're going to market-based sourcing, this is a Jerry Maguire moment. Show me the money. Who pays me? That's what those cases say. Who pays the taxpayer? Don't look through my customer pay through it. It's not going through who's paying me. Who am I invoicing at the end of the day? Okay. And the problem with these cases too, and a lot of the market-based sourcing, which I just completely don't understand, is this concept of billing address. You know, billing address is the most archaic thing. Let's talk abacus. Okay. Billing address, who here gets a physical bill sent to them and they send it someplace? Who gets an electronic bill? How many, from our law firm as an example, how many bills do we actually mail out anymore? You know, maybe for a couple people, but the vast majority are sent to an email. They're sent into a legal support system. We're sending it to an IP address, not a billing address. Where's the IP address? Who knows? Who cares? We don't care. Pay us the money. It's fine. If you want to simplify this, let's all adopt Jerry Maguire statutes. Show me the money. Who's paying me and where are they paying it from? And again, that's not an easy answer. That's trying to straighten out the mess that market-based sourcing has created for us, right? Because where'd you pay from? Well, I'm you know, Fortune 5 company, and I've got banks all over. How do I know which account? Should it even matter? No, of course it doesn't matter. It doesn't matter where I sent the billing address. I'm going to send them all up in Hawaii or the Caribbean or even down here in Alabama. I can send it anywhere. That makes no sense. That's why marketplace sourcing has failed so greatly, because they've created definitions that can't be resolved, and there is no consistency from state to state.
That seemed like a really good time to finally use my mute capability. So I'm going to give Chris an opportunity, if he wants to disagree with anything that Jordan said there.
No, I mean, you know, I actually kind of agree with what he's saying, except for one point. Billing address, if my clients knew that billing address was the first step, we'd all be fine. The problem is it's this alternative step, right? So a state says, well, we don't like this first answer. We don't think your books and records are the best here. You technically don't have a fixed place of business there. So now we're going to go to billing. And you say, well, that was a pretty self-serving answer, right? That to me is the problem. If prong 1 of the sourcing hierarchy was billing address, let's have a field day with setting these structures up.
Let's go. No, and to Chris, exactly to your point, we have a client fighting Ohio on its cat and the whole MIA greenscape issues. And what do they rely upon?
That is the sale of TPP as opposed to intangibles and Defender. But yeah, keep going.
But it's the same thing. It's the same kind of concept. They're relying upon what the bill of lading says. Doesn't matter what the contract says. Doesn't matter where risk of loss does. Doesn't matter where title is. Doesn't matter where the trucks pick it up. They say, well, if your bill of lading says Ohio, we get it. Even though if it gets blown up in Colorado on the way back across from California, it is the buyer's problem, not the seller's problem. They say bill of lading. We've got a client that says, okay, you say bill of lading. You know what bill of lading is going to say? New Mexico. It's going to say something else. Okay, that's your proof. That's the stupidest system I've ever heard of. That's something you can manipulate that has no impact on anything dealing with the transaction, but that's how we're going to decide how to source these sales. Doesn't make sense.
So let's move on to alternative apportionment, which I think is Chris's favorite subject. So as a quick primer to alternative apportionment before we delve into two cases, UDIPA was adopted back in 1957 to create a uniform approach to allocation and apportionment. And although it prescribes a statutory method, it anticipated that a state's apportionment or allocation statute may, as applied to certain taxpayers, violate the fair apportionment prong of complete auto. So to solve this, UDIPA includes Section 18, which provides that if a state's allocation or apportionment provisions don't fairly represent the extent of the taxpayer's business activity in the state, either the taxpayer or the administration may require either one of a few things: separate accounting, the exclusion of a factor, the addition of a factor, or some other alternative method. And although most states have adopted UDIPA's equitable provision, some states have some other similar provision. So keep in mind that it's not just for taxpayers. So either the Department of Revenue or the taxpayer can invoke alternative apportionment, but the burden of proof should be on the party attempting to deviate from the statutory method. So we have two recent cases, Vodafone and Associated Bank, where the department invokes alternative apportionment, but was not really held to that burden of proof. They weren't necessarily required to prove it. So in Vodafone, we have a taxpayer that files a refund claim trying to use the statutory COP method. And the department denies the refund claim. And then 3 years after litigating over the refund claim, the Department of Revenue commissioner issues an alternative apportionment variation letter requiring market-based sourcing. So requiring not the statutory method, but an alternative sourcing method. And in reaching its conclusion for the department, the Tennessee Supreme Court doesn't address the late issuance of the variance. Instead, they just focus on the fact that the taxpayer's income would be substantially larger under this market-based sourcing approach rather than the statutory COP method. It's about 1.3 billion compared to 150 million. So what the court sort of does is invert the application of alternative apportionment, instead concluding that for a taxpayer who is not invoking alternative apportionment to prevail, they have to prove that the variance imposed by the commissioner constitutes an abuse of discretion. Associated Bank, we get a similar decision out of the Minnesota Supreme Court. The court holds that the tax commissioner properly invoked alternative apportionment when calculating a bank's corporate franchise tax liability. I want to explain the structure a little bit because I think it was important in the holding. So the case involves a bank that changed its ownership structure to reduce its Minnesota corporate tax liability. That was really the intent behind it, by forming two LLCs in Wisconsin and then transferring the ownership of Minnesota real estate loans to those two partnerships. Because Minnesota doesn't include partnerships in its definition of financial institution, the bank argued that these new LLCs don't constitute financial institutions for tax purposes and don't have to use the statutory apportionment formula that should apply to interest income that's held on these financial institution loans. So in audit, the commissioner requires the income of the LLCs to be apportioned using the state's apportionment formula for financial institutions and includes the interest income of the two LLCs in the unitary report. So again, holding for the department, disallowing the statutory method, the court concludes that the commissioner produced substantial evidence to show that the bank's apportionment method did not fairly reflect. So the bottom line is you have two cases here where the burden should be on the department as they're the ones that are invoking alternative apportionment, but yet the burden is more or less put on the taxpayer. So here's your question. Associated Bank and Vodafone both set a precedent for states being permitted to use alternative apportionment as kind of like a get out of jail free card when their assessments are completely unsupported by statute. Chris, do you see any daylight between these two cases, and is one more supportable than the other?
I do see daylight. And although I'll say that the trend is frustrating for taxpayers, right? It's a heads I win, tails you lose. I just watched Jerry Maguire last weekend, Jordan, underrated rom-com. And I'll use another line from Jerry Maguire to characterize the Vodafone decision. It's, you had me at more tax. So I think that Vodafone was frustrating because it was completely deterministic. right? What does it matter that market-based sourcing gets you more tax than COP? Market-based sourcing was the approach you didn't adopt, right? Statutorily, you can go in, you can become a market-based sourcing state. You're not. It doesn't matter if one gets you a higher liability than the other. That was very frustrating from a procedural standpoint, and really seemed unprincipled. I'm happy to hear that some of our friends from Bassbury Sims have said what's good for the goose is good for the gander. We've got telecom companies located in Tennessee. You better give them market-based sourcing too, which they ultimately prevailed on. Minnesota, however, I don't like how they got there, but that's not just more tax. That's more of a pigs get fat, hogs get slaughtered kind of situation in my mind. You really had a move that had no substance. It was what pretty much all financial institutions in Minnesota were doing at the time, is taking that property, the loans, and putting them into partnerships, subs. That really doesn't reflect economic reality. And I could understand the department coming in and saying, yeah, we get it, but this is about as close to a loophole as we see. And we think to fairly reflect your business activity in the state, those loans should be reflected in your apportionment factor. Because keep in mind, it's still going into base income, right? It's not like there's a base play here. It's just a question of whether it's reflected in your apportionment factor. I think it's fair to reflect it in your apportionment factor. The thing that's frustrating is the commissioner didn't do that. For the longest time in audit, and even at the first stages of appeal, they were simply saying, no, we're right. This is what the statutory requirement is to include representation in the factor. And then they started getting up 3 years after the assessment, and they realized, oh, bleep, we've lost. Variance letter, and the court just allowed that. I think that it was the right substantive decision, but I think there has to be some process to invoke alternative apportionment, and it can't be 3 years in.
Jordan?
I'm
guessing you're going to agree here, but for sake of disagreeing, you might.
I am, but I'm going to distinguish. And here's my problem with it. And I think Chris actually made a good point. Finally, it's about time that he made a good point. We're 40 minutes in. States pass statutes. Taxpayers don't. Businesses don't. States tax statutes. States have the ability to change their statutes. I get it. They have created the ability, if they adopt it or on their own, to say, wait a second, things don't look right. We want to do something about it. That should be the exception rather than the rule. Businesses do business, okay? And therefore they should be entitled to the statutory language that have been created by the states to apportion their income. When they do something above and beyond, kind of like associated banks, where they try to take advantage of just the slicing of statutory language and not necessarily the intent of the statute, the state should have the right to come back in with alternative apportion saying, you really are not following intent. But states have the upper hand. They can pass the statutes, they can change the statutes, and for them not to like the result, where the taxpayer is just doing business, is completely wrong, fabricated, complete garbage. They should not be allowed to do that.
Did exclusion of those Minnesota loans, though, fairly reflect business activity in the state? I think no, and that's the purpose of alternative apportionment.
Exactly, and that's exactly right. But the states actually have that ability to do it, right? They could, if they want to address it and say, you can't corporately structure this away. If you do this, we're going to throw it back in and treat you as if it came from a financial org and it's just hitting on its own now and it's not a financial org, it's still a financial org. They can do that, right? They have the ability to do that. And they did it kind of through alternative apportionment by saying, yeah, wink, wink, we're not recognizing your reorganization here. That's kind of what they said. I'm going to still treat it as a financial org, even though it's technically split out in a single member LLC, right? It's kind of ridiculous what they did, but we understand it. People are technical readers of the laws, but states' hands should be behind their back because they have the ability to pass the laws. Businesses don't. We have to follow what's out there. And when we follow it, and then they say, well, we don't like the result. That's your problem. And what really makes me mad is that as businesses has evolved, if the states are too slow to catch up, that's on them also.
I will point out, I do think from a theoretical standpoint, it's a legitimate question to ask, should states be allowed to invoke alternative apportionment? It's their laws, right? It should be a constitutional, safety hatch for taxpayers when they say, wait, your statutory method isn't constitutional here, Hans Reese, all that kind of stuff. But when a state just says, wait, we don't like the way our statutes function, they have another remedy, which is to change their statute. Right? But the state statutes currently say, almost all of them say a taxpayer may petition or the department may require, right?
I agree.
And what does that mean? Does it create a different standard?
You're 100% right, because the burden is on the taxpayer to prove that the current standard does not do it, and this is reasonable. The old standard was not reasonable. This is reasonable. States at a minimum have to show the same burden, right? They have to show that while the current statute is not applicable, it doesn't properly reflect your business in the state, and why their methodology does. It should be a two-part test, just like it's imposed on the taxpayer at a minimum.
Yeah, so I agreed. And we've seen that it seems to be an easier burden on the department. Can a taxpayer win? I mean, all these decisions where alternative apportionment is invoked and survives, is the department invoking it? Is it really a relevant method for taxpayers at this point, alternative apportionment?
Well, what if I told you I could get alternative apportionment 90% of the time? And it's not following the statutory petition route. It's how you settle cases, right? It's how you settle almost every unitary business, non-business combination. It's how you settle all those cases.
Right, Chris, how many cases have we resolved on a non-business business gain, sale of the business, blah, blah, blah. You come in, sales factor, historical sales factor doesn't work. Sales factor doesn't work. Let's talk about how we can resolve this and bring in some other factors to do it, right? That's kind of our modus operandi. It's not alternative apportionment. I know of a couple cases where people do the alternative apportionment. They set it out, then they negotiate it and they do it. I would agree with you. That is the exception rather than the rule. It's either done in an audit, or it's done in a refund claim, or some other contest.
Or you go to a state and you say, hey, your statute's ambiguous. We don't, now it's really because we don't like the answer. Your statute's ambiguous. Let's talk about it and come up with a method that we think is a faithful, interpretation of the statute that some might construe as alternative apportionment.
Right. Right. I mean, if you talk about the formal, let's write the state, 60 days before we file the return or whatever it is. And
you're probably losing that.
you're going to lose that. And if you even just to contest their denial of it, it's going to take a long period of time because it just doesn't work that way.
Yep.
But I agree with you. Alternative apportionment exists not statutorily, but through negotiation. And that's really the world in which it lives in.
Mm-hmm.
I think I should have muted Jordan after he said, I agree with you. I just left it at that. All right, so round three. We have a little over 10 minutes, and I want to be able to get through both round three and the lightning round, which I think will be more fun. So round three is discrimination, and we are going to address it in the context of the Maryland digital advertising tax. I want to give a quick background on it, and then we can talk about the viability of the complaint that's been filed at the federal court. So back in February, the Maryland Senate voted to override the governor's veto of House Bill 732, which now will become effective 30 days after the override. So that's March 14th. That's in just a few days. What it does is it imposes a tax on digital advertising services as of January 1st, 2021, using an apportionment fraction based on global annual gross revenue. And it's imposed on some crazy rates. So it starts at 100 million at 2.5%. And then it goes all the way up to 10% when you get to 15 billion in annual gross revenue. The idea behind it was that large digital advertising companies are too big to trust. They've created a haven for dangerous misinformation. That's a quote from the New York Times. The idea is that these advertising services are really trying to get too large, and they want to try to more or less get tax dollars out of them, right? I mean, that's what this comes down to. And there has been a complaint filed in federal court, which some say is a fairer form than state court. But there is this hurdle of the Tax Injunction Act, which generally bars federal courts from adjudicating state court cases. The complaint raises a few violations, the first being that it violates ITFA, the Internet Tax Freedom Act, which prohibits state taxes from states from imposing multiple or discriminatory taxes on electronic commerce. It also alleges that Maryland's imposition of the digital advertising tax violates the Commerce Clause by imposing progressively greater liability on companies for revenue they earn outside of Maryland. The idea being that there really won't be any Maryland companies that meet these thresholds. So they're going to be primarily out-of-state companies that exceed it. And there's also an argument with respect to the Commerce Clause that there's a substantial risk of conflicts with foreign governments because you have other countries like France and continents like Europe where they're raising and imposing these advertising taxes. So it's preventing the federal government from speaking with one voice on foreign policy. And then lastly, there's a due process argument with respect to extraterritorial conduct or activities. So Jordan, the complaint filed in federal court raises, again, a few different challenges. ITFA, Commerce Clause, Due Process Clause. If it is, one, is it going to win at federal court? And two, if it does, on which of those grounds is it most likely to win?
All right. Well, first off, let's set the standard straight. It's no longer IFTA, it's PITFA. It's the Permanent Internet Tax Freedom Act. That's the one in 2000.
I refuse.
That
It's always
IFTA. Right. So for those that are confused by the PITFA and ITFA, it's PITFA now. That is the name of the statute that passed it, made it permanent. And speaking of PITFA, from a, we've talked about getting to federal court. There seems to be a push to get these kind of cases in federal court to adjudicate national issues, constitutional issues. And I don't think they survive. I do think if it is going to survive in federal court above the Tax Injunction Act, it will be on the PITFA question. It's going to be whether this is a violation of federal law, and the reason why is the imminent danger, not just of Maryland's passing it, but of the other dozen states that have now proposed it or are working on a proposal. So they got to stop the plague before it spreads. That's really, what it's about. So if the federal court's going to take it, it's going to be based upon the absolute violation of the Internet Tax Freedom Act in a national basis. Whether it's discriminatory, due process, Commerce Clause, equal protection, the courts like to push that back on the states and say, states, you figure that out. We'll deal with that, even though it's a constitutional provision. But in a direct conflict between a state law and a federal law, perhaps is best served in federal court. And I think if it survives, it will survive there based on the Tax Injunction Act or overcoming the Tax Injunction Act biases. Do I think it should? It's clearly discriminatory. And here's one of my problems with it. The discrimination is against regular advertising, right? Not digital advertising, regular advertising. And a lot of regular advertising you find in newspapers. Newspapers bring in a whole nother constitutional provision, the First Amendment, right? They're protected from being taxed by states because it's a freedom of speech. So how do you get over the hurdle of making newspapers taxable to equalize them with digital, and then overcome the hurdle that you have to with the First Amendment, saying now you're impinging upon the right to free speech? And, maybe advertising is free speech as well. Maybe what the internet, the seller of the internet space is advertising. Maybe it's an online newspaper that is advertising. How do you distinguish between an online advertising in a newspaper and online advertising that's in print? Doesn't make any sense to me.
You can respond to that if you want, or I'll pose you a secondary question, which is, if you're a taxpayer, you're trying to decide whether you're going to start, it cannot be passed on that there is a pending.
Well, that's a bunch of crap, right? We all know that. You can't pass on a business input, tax on a business input. Yeah, okay.
Practically, though, are you going to begin to plan for this tax? What's your practical recommendation here to taxpayers?
It's an unlawful tax. It does violate PITFA. But until it's declared so, I think you have to comply with it. File a protective refund claim. I think that filing in federal court was a mistake.
Well,
Easy enough.
Well, and I think the question is, can we get a temporary restraining order preventing the imposition of the tax? Really, that's really the big question here. Like we've done in the Cook County cases, the Chicago use tax, Cook County use tax, we've pushed back on that, and you go to court, you get it in state court, a TRO to prevent them because of the damage it can be done. I'm not sure you're going to get that at the federal level. I'm concerned about the feds wanted to step into states' business and their ability to tax, specifically in light of the TIA, right? Tax Injunction Act said you can't do that in federal court.
The thing about it that does make me a little concerned, your newspaper point notwithstanding, is that it's often an easy fix. If we go back and look at the performance marketing case in Illinois, what did they do? They got their click-through statute struck down on an IFA basis. I think it was the first case to do so.
Yeah.
And then they just amended the statute and added catalogs.
Right.
And it doesn't just discriminate against internet transactions, electronic commerce anymore. So that's my real concern. I think the writing is on the wall here. It's been going on throughout the EU for a while.
But what do you think about size? I mean, 100 million seems like a reasonable number. You're big, certainly at $100 million in sales. But what if you're strictly a Maryland-based, $10 million company? Do you get escape to tax then? And that's one of the counts that was in the complaint, is saying, well, this won't hurt anybody in Maryland. So that's discriminatory against interstate commerce. It's all going to be the California-based companies.
States say the same thing, though, when they adopt single sales factor and market-based sourcing, right? It's always the goal. I struggle with whether it's discriminatory to set that receipts threshold for a few reasons. It's not quite the same as a progressive income tax because every dollar under a progressive income tax is taxed at the same rate. But I think that leads us to the whole CSX dish kind of cases. Is a $10 million retail or advertiser similarly situated as a $100 million, and is there a reasonable basis to differentiate between the two? I think dollar figures are a reasonable basis. Didn't we just talk about that with respect to receipts thresholds?
Yeah. And I was stalling so I could gather your Q&A for the lightning round.
Woohoo! Lightning, baby. Thunder and lightning. Thunder, lightning.
Can see some of your questions in the Q&A. I'm going to start out with one of ours here while I gather those, which is, Jordan, you've got one. No, I'm going to give you 30 seconds.
Oh
30 seconds.
I have to talk fast then, which I haven't done this whole time.
Yeah, no, you talk so slowly. We've considered fair apportionment in the context of income tax. Does it apply to sales tax?
It should. If it doesn't, it absolutely should, because having one single winner and one single loser, all the other losers, doesn't make sense to me. And with respect to things other than tangible personal property, when you're talking about a service and we get into this where the benefit is enjoyed or where the service is delivered to be your, oh, I'm stuck on 27. I get to talk forever. I love it. When you get into that, it doesn't make sense to say one's winner, one loser. Software services, you have a database, you send it out, everybody can subscribe to it around the country, and you say one state gets it because the billing address is on it. That's the most ridiculous thing I've ever heard. And to their credit, again, City of Chicago, lease transaction tax, give me an affidavit that this software is going to be used in multiple jurisdictions and I'll give you relief. That's the answer. I can't believe I'm applauding Chicago, but they deserve it.
Complete auto was not an income tax case. Fair apportionment absolutely applies to indirect taxes.
Boom.
Done. All right, so I'm going to try to kind of combine some of these questions with what we've got here. So one of the questions that we have here from, I won't disclose who's asking the questions, is whether you guys have any thoughts on the sales of digital goods for purposes of Public Law 86272. I think we mentioned this earlier, but we can hammer it home. So is it exactly the same format as digital? So under a recent audit, they've encountered the New York Department of Revenue saying that it exceeds Public Law 86272. So would you take that position?
Are we talking streamlined sales and use tax agreement, bread and butter digital goods, true digital goods that are distinguished and separate from TPP? If so, 86272 doesn't apply in my mind. And when we know that digital goods, New York has addressed this in the context of virtual currencies, digital goods not taxable in the state of New York. So if they're not treating it as TPP for sales tax, which is something you can look to, but it's not, it's not dispositive, then I would say 86272 very clearly only applies to TPP.
And I can't believe, let's talk about evolution of a statute interpretation under today's law, that if I get a digital newspaper, okay, that creates Nexus. But if I buy the real newspaper, it doesn't, because one's tangible, one's not. The content's the same. The delivery methodology is the same. And if we're talking about delivery, the way you deliver something to distinguish whether you're protected or not protected, either get rid of 86272 or bring it up to date, right? That's really what it should be. If it is the functional equivalent of TPP, it should be protected the same way as TPP. It's just modernization. Its technology has changed. Either the statute should apply or it shouldn't apply. And if it doesn't apply, let's just get rid of it. But to make that distinguish, to me, is just wrong.
Yeah, I think going back to local taxes in the context of Nexus, there's a question about Louisiana. So the locals in Louisiana have fought for their state constitutional rights to levy and collect their own taxes. And they won that in court at the Louisiana Supreme Court. They said that the legislature can't take that right away. So let's revert back to our earlier discussion about local taxes and Nexus. Does that sort of impact your analysis at all? Do you view Louisiana to be its own separate beast?
Not under the Commerce Clause, I don't.
What, you don't think? See, I do. They sued in court to say we can impose, we can collect, we can audit our own taxes. The heck with you, state. We don't want to give you anything. And then they're saying we don't have an obligation to post a Nexus requirement as to when you're subject to tax. Even something as simple as saying, if you're subject to Louisiana tax, you're subject to our tax. I'm good with that because at least it's the standard. But to sit there and be neutral, give us nothing, completely unfair.
But if you have Nexus with Louisiana, and the locals don't have a standard, the Commerce Clause is not concerned with that situation. because it's an intrastate issue at that point.
I agree with you, but we're talking fairness, and that's due process, and they are a political subdivision, and they have to give us due process of law. And I understand the standards are low of that, but gotcha is not due process of law.
I don't think due process requires the thresholds, but we've already argued that.
Yeah.
All right, one final question, and then we're going to cap this because I think we've answered most of the customer questions here, and we're at 1 o'clock here. We're at time, so we perfectly fit this within an hour.
We gotta go.
So I wrangled these cats into an hour, and I feel pretty good about that. So final question for both of you. States generally impose sales tax on DPP and specifically enumerated services. So many of which were created decades ago. You've got Texas with data processing and information services. Do states have the authority to apply sales tax to something more recent like streaming services under these enumerated services, such as a data processing again, or an information service? And there are a few states where I think this is most relevant, being like a Connecticut or a Texas, or maybe a Florida.
It depends. To Jordan's point before, if there is a clean through line from a previously taxable item to a new item, and they say we interpret that to fall within that umbrella, I think that that's reasonable. Things like information and data processing services and the interplay with things like software as a service makes sense to me. I would prefer, however, for them to follow something like the streamlined approach, which is here, we're dealing with this uniform set of definitions. Tell us whether it's taxable or not. We're sort of agnostic as to whether the answer is yes or no, but we want to know.
I mean, information's the key here. Communication. How many times in a direct conflict is communication the problem? Almost always. It's communication. Tell us what it is. And again, states have the ability to change their statutes and impose their statute. The problem, what they do is they take the old statute and now they apply it retroactively. That's what every audit is. It's a history lesson. They apply it retroactively. If you had given me warning, I would have done something different about it. And from expanding the base to services, that's a policy question. Because think about it, if you tax all of this stuff, it ultimately goes on the consumer, right? Do you want to put your citizens to that test? That's what the question is. But don't punish me retroactively by now interpreting something. New interpretation, bring it forward and put everybody on notice. And then you've decided that your citizens should pay, your residents should pay. That's what states can do.
And look, the idiom is so worn out now in the area of state taxation, but there really are a lot of square pegs going into round holes in audits right now with respect to this question.
All right, well, Jordan, do you want to have one last word?
Thank you.
Yeah. One thing I do want to mention is we don't have your typical types of slides for this presentation. So I will say that Chris has written a few really great articles, alternative apportionment. I have one on ITFA that I think helps explain the Maryland digital advertising tax and some potential ramifications of the implication of ITFA. So if you want to reach out for any of those, anything else you guys want to plug here before?
We can send our PowerPoints and slides or presentations we've done. Just go on the website, see one, let us know. We'll send it out to you. We've got no problem with doing that. This is going to be available on YouTube, so you can show it to your kids and grandkids because it's obviously fun. Show it to your dog if you got nobody else. But thank you again for joining us, for staying with us. We've really had a good time. Chris, Sam, and I, actually, this is just another day in the office, debating over topics and how we best serve our clients.
But I think we have the most important Q&A still remaining here that we need to do, because I think or the last remaining poll, we need to crown a winner. So let's go ahead and relaunch here.
AYSO soccer, we're all winners.
We're stuck on 3 here. So
I'll also plug, I've got an article on 86272 called What to Do with Public Law 86272 if anybody's interested. Yeah,
I'll plug my hump day humor. If you guys want it, just send me an email. That's my writing days. Not as much fun as it used to be.
Who scored the most punches during the SALT face-off? Was it Chris, the professor, the fighter from the East Coast? Was it Jordan, the fisherman, the veteran that can't be beat? Was it a draw? Or did we all just have fun?
I'm going to give the crown to Sam for muting Jordan.
I had to do it at least once.
That was a great move.
I feel like he wanted me to. He just kept going. I think he was testing me.
Just as a kid, asked my parents, always testing the system.
All right. Our winner is a draw. They both did great. A round of applause to our two fighters. I think you
Thank
guys
you,
did
guys.
awesome.
Thank you so much for,
Yeah, thanks everybody for attending. This was a lot of fun.
yeah, be safe, have fun, stay healthy.